all staff. Okay, good morning. Want to take roll, please, Sasha?
Commissioner Hatch? Here. Commissioner Hayward?
Here.
Chair Remke?
Here. Okay, just to note that if anyone's listening and trying to watch the live stream, we are unable to live stream today, but the phone line is working for the call-in, so I'm assuming hopefully people have figured that out and are listening now. And then I just wanted to also take a moment to point out some new developments we've had regarding our top 10 list that have been pretty positive and exciting from my point of view, which thanks to Phil and Trish, they looked at the data on our top 10 list regarding ballot measures for 2014 and 2016 and did some analysis about what's happening and some trends. And we've posted that on our website, so when that's back up and running, hopefully you'll get a chance to take a look at it and the data visualization that's been added. But in light of the upcoming election and all the money we know that will be pouring in on new ballot measures, I think it's really an interesting thing to look at and take a moment to study, which number one, which I keep trying to stress, is that the top 10 list on ballot measures does show where 85% of all money going to ballot measures come from. And that's pretty significant. That's both 2014 and 2016. It also shows an interesting trend regarding money from out of state. In 2014, I think it was about 7% of the money came from out of state. 2016, that number jumped to almost 30%. This is on our California ballot measures. So again, there's some interesting information there. I think it's worth a look. I mean, we take all the time and effort to collect this information, and we're trying to push out some really usable, helpful information that comes out of it. So thank you, Phil and Trish, and thank you, IT, for working with them to get that up. Okay, so public comment. Any public comment for an item that is not on the agenda today? Okay, hearing or seeing none. First item is approval of the commission minutes from November. Any corrections or comments from the commissioners? Is there a motion?
I'll move it if you'll second it.
Commissioner
I second.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Chair Remke?
Aye.
This motion passes.
Okay, next we'll move to the enforcement consent calendar, items 3 through 34. Do the commissioners have any items they'd like to pull from consent?
I have some, I'm sorry. What was the other term you used where you just want to talk about them but not pull them up?
You don't need to pull them. I'll just ask you if there are any questions when we come.
Okay.
Is there anything that you need to pull because you want a separate vote on is really the issue here, or because you need to abstain from the vote or otherwise recuse yourself?
Okay.
No? Okay.
Hello, I'm Galena West Enforcement Chief. We are pulling number 5. As of 5 minutes ago, we have reached a settlement, and that will be presented to you hopefully at the February meeting. So.
Okay, thank you for those ongoing efforts. Do you want to talk about it at all anymore, or just tell me, because so now we still have this pending default, which I don't want to lose sight of because I was prepared to vote for the default. But so you've reached a settlement. Is it signed? Are we going to come back with?
The settlement is signed, and hopefully we will come back with full payment in February.
Okay, and if we don't have that by February, I would hope that we'd be right back here looking at an $18,500 proposed
We'll be presenting
default.
the default in March if the February settlement is not presented.
Okay.
Finally opened her mail?
Okay,
You
so
don't have to answer
thank you for that. So number 5 is pulled, and then we'll start with any remaining questions from the commissioners regarding the consent calendar. Do you want to start, Commissioner Hatch?
Thank you. I have questions, comments. It's common to all of them, like 6, 7, 10, 11, and 13.
Let's start with 6. Go ahead.
Okay. It comes, all of these are not, well, some of them are streamlined, as it turns out. Most of them are not streamlined. And this is kind of like an old saw for me, so I just, as a group, let me just note that the fines for missing semi-annual or other reports is generally $2,500. The 24-hour reports are aggregated into one charge and wholesaled at $2,000. I mentioned a number of times before that I think missing 24-hour reports are much more important than these annual or semi-annual reports. I'm not going to ask that they be pulled off and renegotiated, but each one of these has the same thing in common. All of the, even though they're not on the due on the same date, they're all treated as one count and then discounted. And I would like in the future to see them, just as in the streamlined settlement, they're treated separately and fined separately. I would like to see that happen. And I think their fine should be as higher than a semi-annual or annual report.
Okay. Galena West, can I ask for clarification on one issue? Do you feel that about the entire 90-day period for reporting in 24 hours, or do you only feel about it as strongly about the last 16 days where it's not reported before the election?
Yeah. Most important to me is that period after the final pre-election report.
Okay.
If it's in their pre-election report, obviously the 24-hour thing is sort of meaningless, really.
Right.
But that's what I'm focused on. Thank you.
Thank you.
Any other comments on item 6 from you, Commissioner Hatch?
No, that's it. Thank you.
Did you have?
Well,
Commissioner Hayward?
I think just to reflect on sort of how I look at the 24-hour reports, I think that the 90-day period, especially when you're talking about special districts and smaller local governments, is really very inclusive and can really be a trap for amateurs and the unwary. So I agree with Commissioner Hatch that last period is really, I think, where the rubber hits the road, because otherwise you're not going to have disclosure before the election, and that's where people are going to be trying to game the system and avoid disclosure. So, but so in addition to looking at proximity to the election, I think also looking at the relative size and sophistication of the committees at issue is important, because we have this sort of one-size-fits-all statute, and we regulate a variety of entities. You know better than me. So that's all I would add. Thanks.
And that goes for the other ones as well. So I have nothing further.
So nothing further on
those other
on the consent.
numbers.
Okay, so
They're
that
all
was
in
kind of an
common.
overall statement. Okay, Commissioner Hayward, any questions for you on the consent calendar?
None. Thank you.
Okay, any public comment on the consent calendar? Okay, seeing or hearing none, is there a motion?
I move.
So items 3 through 34 minus 6.
I'll second
No,
that.
I mean, actually, sorry, minus 5.
Minus 5. Yeah. Yes.
Yes, there's a
As
second.
corrected, I second.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes,
This motion passes.
Thank you very much.
thank you. Okay, so starting with item 35, adoption of amendments to the regulations to reflect the changes in the law as a result of the Disclose Act.
Good morning, Chair Remke and Commissioners. Suki Barr, Senior Counsel with the Legal Division. I'm here to present proposed regulations implementing AB 249. This is the first set of regulations, and We ask for the Commission's support and approval of the proposed amendments to these 9 regulations. And with that, I will open up to questions.
Okay, any questions from the commissioners regarding item 35? No. Are you okay?
Yeah, I just want to sort of reiterate for everyone participating in the process. It did seem to me like these were very focused on the fact that our regulatory language at 18225 is now moved into the statute, and so we need to make conforming changes so that the now non-existent 18225 doesn't have any cross-references. It's pretty much.
Right. Most of these are mostly technical in nature, eliminating, can you hear me? Eliminating language that's no longer needed because of AB 249. So you could look at these as mostly technical in nature, trying to implement the bill at this point. There's one minor amendment that doesn't have to do with AB 249, but it's a minor one, and then some grammatical changes. So.
Okay, nothing further.
Okay, any public comment on item 35? Okay, seeing or hearing none, is there a motion?
I move the agenda item.
I'll second.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes.
Motion passes.
Thank you, Suki. Okay, item 36, adoption of amendments to Regulation 1845.1, definition of advertisement. You gotta move that.
Good morning. Karen Harrison, Commission Counsel, Legal Division. I'm here to present the proposed amendments to Regulation 18450.1. This regards the definition of advertisement for purposes of disclosures under the authority of Section 84501. We're presenting a number of amendments which reorganize the regulation, clean up some of the language, as well as conform with AB 249. Substantively, looking in Subdivision A, we have proposed language to add a few terms under electronic media communication. This reflects the language in AB 249. And we also address the overflow issue or the carryover issue of yard signs. This was presented to the Commission in October at the pre-notice hearing, and that was the proposal to define yard signs for some clarity to the regulated community as signs no larger than 6 square feet. This is now presented as option 1, and this language is carried through. That is the substantive change that would occur. We also are proposing an option 2 to the yard sign language following our November interested persons meeting where this regulation came back up again. Proponents of AB 249, the California Clean Money Campaign, requested that yard signs be subject to campaign disclosures like billboards at the threshold of 1. And so we have prepared option 2 to reflect that request. Subsequent to that, we additionally received another request from the California Clean Money Campaign that suggested the removal of thresholds as to ballot measure committees, independent expenditure committees, and ads paid for as an independent expenditure. We are not proposing or recommending that option at this time. The threshold of 200, which is in the regulation, has been in the regulation since it was adopted by the Commission in 2002. It was put in place to protect small actors in the political campaign community. It balances the public need for information with the right to free political speech. And this is under the authority of the Commission to set these thresholds under Section 84501. It is still under the authority of the Commission to set these threshold levels as that section was amended by AB 249. Looking now to Subdivision B, we're proposing removing language which is now duplicated in amended Section 84501. The remaining language reflects the burden of proof when a committee is claiming an exception from disclosure requirements on electronic media due to the disclosure being impractical or severely interfering with the message. This reiterates the burden of proof requirements under Evidence Code 500, which places that burden on the claiming party. And then in subdivision C, we propose to relocate the reference to aggregation rules applicable to determining when a contributor has reached the $50,000 threshold. This language is currently in Regulation 8450.4, which is proposed in the January set of proposals for repeal, with the exception of this language. All of the language in that regulation is now not needed, with the exception of these aggregation rule references, and we believe it's appropriate to relocate that language here in this regulation.
Okay, thank you. Questions from the commissioners? Commissioner Hayward.
Yes, thank you, Madam Chair. So I guess I would, first of all, opt for option 1 on the yard sign. I understand that the notion that there's a differentiation is, sort of a threshold notion. It's a notion that we've been living with for a while, and it would occur to me that to provide for first document disclosure in that way does run up against things like the McIntyre decision and other places where the court has found that, at very retail levels, the same amount of disclosure isn't really justified. Now, what I'm curious about is the burden of proof question in 18450, 3B, I guess it is now. And you cited Evidence Code 500, which, like Matthew Peterson, it's not coming trippingly off my frontal cortex. What does Evidence Code 500 say, and why does it relate to what we're talking about today?
Evidence Code 500 says, except as otherwise provided by law, a party has the burden of proof as to each fact, the existence or non-existence of which is essential to the claim for relief or defense that he is asserting. So
you're treating this, excuse me, go ahead.
I was just going to say, this burden of proof language is currently in the regulation. It's been in the regulation since electronic media was added to the regulation in 2010. And so then it is just continuing that existing language. Mm-hmm. And the burden of proof referenced is the burden of proof that we use in our hearings. And so that is what is controlling as to what needs to happen if a committee is claiming this exception from disclosure.
Why is it underlined?
I'm still working. Thanks. Does the California Evidence Code look at different forms of burden shifting or different identifications of the burden of proof when we're talking about, I don't know, things like First Amendment claims, religious freedom claims, speech claims, SLAPP suits? I mean, because I think what you're saying to me sounds like the general rule, and I'm just wondering if there's exceptions to that general rule in the Evidence Code.
I don't know the answer to that question, but what I can tell you is that this is applying to a particular situation where there's an electronic media communication, it's an advertisement, and a committee would be claiming that they fall under an exception to the disclosure rules and that they can put a hyperlink instead of having the actual disclosures that are required under AB 249. So they would be claiming that exception. And under the section, the way it's written, that burden of proof is on the committee, and we are including it because it's existed in our regulation. We're including that language just as a clarification. And if I may, there was a question as to why it's underlined. It's actually later, if you look further down in the regulation, if you look under subdivision B, and then let's see, 3B, the language is there, and this is, it's stricken and then underlined because it's reorganized. So we've just moved the language up because all the rest of the language has been deleted as duplicative.
is that page 3, line 8? Is that where you're talking?
Yes.
Correct. So if you look actually on line 9, any committee that claims or required to disclosure in an electronic media advertisement is impracticable has the burden of establishing that a disclaimer could not be included due to the above factors. So my apologies if that was confusing.
I see. The only difference is the word proof.
Commissioner Hayward, were you done?
Yeah, I think I am. Thank you.
Commissioner Hatch, questions?
Okay. So you consider that first phrase there just a title?
Subdivision B where it says burden of
On
proof.
Page 2, line
16.
16?
Yes. That was just for clarity.
Okay. All right. I had some questions around the letter that we received fairly late about from the Clean Money Campaign relative to the application of these regs. And on the, I think it's the second page of their letter, at the very bottom, it says, "We therefore respectfully request that you amend paragraphs 3, 4, 5, 6, and 8 of the draft regs to only apply the ads to paid for by, quote, a candidate control committee established for an elective office for controlling candidates or a political party committee." And then they go on to, in essence, say that anybody else, which is, your independent expenditure campaigns and so on, would be from the first impression.
Correct.
And your option B, I think, doesn't conform to that. Could you explain to me why you diverged from that?
Option 2 was in response to the comments that we received at the November Interested Persons meeting. And at that time, the comment was that that yard signs should be likened to billboards. And then this comment that's come in later is saying that that would apply to telephone calls, print media, flyers, door hangers. And so option 2 was drafted prior to this letter being
So it
received.
seems like we need an option 3, huh?
That is a possibility that the commission can certainly look at.
Because I wouldn't want to sweep all of these categories together when the statute seems to make a distinction. Don't you think?
Well, we had some concerns as well when you talk about applying no thresholds to a door hanger. It's a little bit different situation perhaps than a yard sign.
Right, but as I read it, what he's trying to say is that your traditional campaign committee would not be subject to the first impression requirement. It's just the hard to identify money that comes in and does all sorts of nefarious kinds of things to confuse the public.
So the no thresholds, as he's requesting, would apply to ballot measure committees and independent expenditure committees, and also independent expenditure ads paid for by these other committees, by the candidate committee, candidate controlled
They did an
committee.
independent expenditure, which is not within their traditional role.
Correct.
And do you have a problem with that, or?
It's not our recommendation just because of the fact that these thresholds have been in place since 2002 with the idea that they protect small actors, and that protection would be taken away. That was our concern.
And how do you identify a small actor? I think we had a conversation, not you and I, but 6 months ago or so, about small actors and big actors, how difficult it is for you to be able to tell in advance which they are.
I think the difference would be between a group that is sophisticated and aware of disclosure campaign rules and perhaps a group that is just coming into the system and qualifying perhaps as an independent expenditure committee and might run afoul of the the disclosure rules as applies to one item, whereas those thresholds kind of gave them a chance to have 200 printed flyers before they had this requirement to have the disclosures, and subject to the fines that could come if they did not have the disclosures.
I tend to come down on more clarity that if you're in a certain category, a committee, one set of rules ends up serving us better, because you can get in trouble with the 200 just as easily by doing more than 200 and not realizing that there was even a limit. I would like to see this go back and get redone and try to incorporate the recommendations of the Clean Money Campaign relative to these issues. I realize it came in late, so I don't mean to criticize. I just think we should work it through.
If I could have some clarification, is the entire, I'm not sure what the direction is for January. We're requesting adoption of a number of amendments, and perhaps there's a way that we could focus in on what needs to be addressed in January. If the commission could give us some direction that the rest of these changes are agreeable, then we could focus in on option 1, 2, and 3.
Well, I'm not even sure we have consensus here, because
I'm fine with the package you brought forth. I'm not sure I'm fine with the burden shifting, but I think my argument is with the evidence code, not you.
so good luck
Or
with that.
until I figure out which lawsuit needs to be brought, or somebody writes me an email when I get home to say, "You idiot, that's not what this means."
But I want to, I just want to see again about if we have even a consensus of what to recommend. So you, Commissioner Hayward, were leaning towards option 1?
Yes, option 1 on the yard sign.
So
Absolutely.
leaving the thresholds in for both the door hangers and the yard signs?
Yep.
Okay. So,
Yeah, no, I'm all about maintaining the thresholds. I do think it matters, because we could be conceivably talking about a one-off or two-off document down the road, and I don't think we need to go
because
there.
I'm getting lost in the subsequent proposal regarding doing it by committee. So with that, what would that look like? Can you help me understand, Karen? So is the idea that we'd still keep the thresholds, but then narrow it also by committee? I don't even understand what the proposal is.
I'm not sure. Are you
I'm
referring
referring to the late suggested amendment from Clean Money about.
You mean what that would look like if we were to come up with an option 3?
Yeah, what would the option 3 look like in your mind, as far as you understand it? Because I don't understand it.
I've considered a number of ways of addressing it. I think the way it's written in this letter, you would add to each category 3 through 8 that it only applies to these listed committees.
Or you could put it at the beginning of the section so that it would apply to, because it does apply to virtually all of them, doesn't it?
Yes, and then it also has a request that the telephone communications be increased to a threshold of 500 as applies to those committees.
For all of them, or just certain? I thought it was just certain, like,
It would be for 500 for the candidate committee, the candidate-controlled committee established for elective office, and the political party committee.
but for all the different categories in paragraphs 3, 4, 5, 6, and 8.
All the rest, the request is to remain at the 200 level. The 500 is reflecting section 84310.
Right, which is, I thought it just applied to one of the categories in this reg, but I guess I'm wrong. So they're suggesting you change it from 200 to 500 in all those paragraphs.
No, only to A3, which has to do with
Just
telephone
A3.
calls.
Okay,
Yes,
I thought it was just one category. All right.
yes.
So we're going to have 500 and 200 and specific committees. I mean, I feel like we're going in the wrong direction of simplifying rules and regulations by carving this out and cutting it up. I don't even understand what the proposal is, so that's my position. But
To go further then, to be in compliance with their wishes, if 3A were changed from 200 to 500, the rest left the same. And at the beginning of the section, before you come to A, if you put the parsing language that they want as to which kinds of committees would be nonetheless, from the first impression, first copy, however you want to say it, and that the candidate committee itself and the party would still be subject to these 200 limitations, except for the one that's 500. That would be my wishes.
To present.
Fair enough, or do I need to do that a different way?
So, I'm sorry, so you're saying that at the very beginning of the regulation, you would want to see the narrowing of the language to the particular committees?
Right. And then a provision that says that for these other committees and activities of certain other committees be required to disclose from the first impression. Which is essentially the independent expenditure activity.
I think it would require a little more modification, just because we have A1 and A2 that are more definitional and don't relate to thresholds. We really only get into thresholds once we're starting with 3.
Well, I'd be satisfied if you add that language over and over, but I don't think it really matters. I think you could have it at the beginning, and it wouldn't do violation to 1 or 2. Actually, 2 is being stricken, renumbered. Yeah, I don't think it would conflict if you put it at the beginning, but, you're the lawyer, I'm not. So if you feel more comfortable with adding those provisions over and over, in each of those subdivisions, I'm okay with that.
well, do you have other comments other than drafting in particular? Because I still just have a question.
Oh, go ahead.
Thank you. I really am still trying to understand what the proposal is. Is it that the 200 exception, the quantity would apply to everyone but this list here? Is that right? The candidate controlled, and political party would not have a 200
Yes, they would.
threshold?
Just backwards.
Really?
So
We're giving the most sophisticated people the 200 threshold?
Yes.
The candidate committee and the party would be subject to basically what you've always done, the 200 limit, except that one provision in 3, which would be 500. The pros that do independent expenditures would be subject to first copy.
Well, okay. Well, I guess I would say the pros are the candidate-controlled committee, and the political party. So I don't understand why would we be distinguishing these groups. I think we're just going down a road of how complicated can we make this? I'm talking. You have it, and I'm talking to Karen. So I want a response of so now we're going to have 500, 200 disclosure depending on what kind of committee you are. So there's 2 or 3 different elements to whether or not disclosure needs to be on there.
It does get complicated.
All right, so
Well-
that's the direction you'd like to go into.
I would remind the chair that we are also required to have our regulations in harmony with the statute itself. And he's pointing out that we're not in harmony with it.
I understand.
He's making recommendations how you can be in harmony with it, and I won't support a draft that's not in harmony with the statute.
Okay, so, thank you.
If I may make a comment addressing that, the legislature hasn't specifically addressed the thresholds. And so I'm not sure that it is not in harmony with the changes in AB 249. The legislature was aware of the regulations when it passed AB 249 and didn't specifically address it. And the presumption is that if the legislature hasn't specifically addressed it, that it remains in place, that it continues. And I know the legislature is looking at cleanup language for AB 249, and possibly if this is an issue they have on their list to address, but as it currently stands, they didn't address thresholds in the legislation. So the regulations, just given case law and some research that we've done, the regulations would stand.
Where do you think you got that 500?
The 500 for telephone calls, that's in 84310, and 84310 has been 500 telephone calls since it was enacted, I believe, in 2006. And so that has been in existence, and
yet
our
regulation
threshold.
calls for 200.
Yes, and our regulation has been in existence since 2002, and there is some overlap between the two, but this has been in existence.
But one's robocalls. I mean, they're different calls we're talking about, right? Is that the issue, the 500 versus the 200? Like the 200 in the regulation is all calls,
Correct.
and the 500 in the statute is regarding robocalls.
Yes, it's substantially similar for
But we're not
telephone
in harmony
calls.
with the statute in that regard.
No, because those are robocalls, and these are all calls.
So if you make one phone call, or if you make 200 phone calls, they don't have to be the substantially similar robocalls. You can have paid-for telephone calls that are not that same category.
How do you get 500 robocalls and be in compliance with subdivision 3, which limits all calls to 200?
I think that in the past, the interpretation has been that 84310 covered those robocalls, and that the 200 picked up telephone calls that were in that other category.
How about live people?
Yeah.
You said this is all calls in 3.
Yes.
It doesn't distinguish whether it's a
It's-
live person or not.
It's telephone calls not solicited by the recipient. But again, the 500 and the 200 have been in existence together for many, many years. The 200 came in first in 2002, and then 84310 was enacted, I believe, in 2006.
We just ignored it in 2006?
I think that there was seen to be some overlap, but it hasn't created a problem.
Not until you charge somebody.
Isn't it that 200 is the basic, and then 500, a new requirement is added on the robocall? I mean, I don't think that they're inconsistent, but so you want the 500, right? Is that correct?
Right, I mean,
Okay, so,
it's either that or you bifurcate this to distinguish actual voice calls from robocalls and have them listed separately in here if you want to be right, but otherwise you have to honor the 500.
okay. I'm going to ask for public comment, and then we can come back to how we're going to take action on this. Is that fair? Okay, public comment.
Thank you. Hello, Trent Lang, President of the California Clean Money Campaign, the sponsor of AB 240. Sorry about that. Trent Lang, President of California Clean Money Campaign, the sponsor of AB 249. So hopefully I can speak to the intent of the legislation. We also have a representative of the author here who can also speak to the intent of the legislature as a representative of the author. So first of all, we'd like to thank the commission and the staff for their good work on these regulations. This is the one that we have the comment on, but the other regulations we're very happy to see do seem to be fulfilling the intent of AB 249 as far as we as sponsor see it. I think I can answer a couple of your questions here directly. These numbers were explicitly the intent of the sponsor, the author, and we believe the legislature. That's why they are clearly written in the code the way they are. Section 84305, as it described in our letter, does specifically address only communications, mass mailings, and mass electronic mailings by candidates, candidate-controlled committees established for an elective office for the controlling candidate or political, my apologies, committee or political party committee. It has different disclosure requirements for candidate committees and political party committees. The intent of AB 249 was to only address advertising disclosures on ballot measures and independent expenditure committees, those ones that have the secretive problems that so many people are concerned about, as you saw in your hearing a few months ago. So 84305 is essentially the same as before, but narrowed explicitly to just those candidate and political party committees. That's where the number 200 comes in. 84310, that is also exactly the same as was implemented in 2006 with some additional clarifications. And I'll note that it does not only apply to robocalls. It actually says 84310, as in AB 249, says these sorts of committees that to pay for telephone calls that are made in similar nature and aggregated 500 or more number, made by an individual or individuals or by electronic means. So there's no difference. So it's both robocalls and paid phone bankers, basically. So what that would be for, from candidate and political party and slate mailer committees. The rest of the code in AB 249, which, as you all know, was basically completely revamped because we were changing the disclosure format for ballot measures and IE committees, other kinds of committees than those, does not have any quantity, explicitly does not have any quantity requirements in there. Those only places that you see the quantity requirements are in 84305 and 84310. And in fact, the sections in AB 249 that describe the actual disclosure formats for those types of for radio ads, print ads, robocalls, et cetera, in 84504, 85402, 85403, they again do not have any quantity requirements. And I'll also note that 84305 and 84310 actually do not redefine what an advertisement is. All they say is that those candidate and political party ads for those types have to have the disclosure only in quantities of over 200 or 500. So this is an explicit reading straight from the statute.
So it's a threshold that certain committees are mailed to, but certain others are not.
Yes, and there's a good reason for that. The intent of AB 249 was to address the problems of disclosure on ballot measure committees and independent expenditure committees. As the floor manager in the Senate, Senator Ben Allen, said on the floor of the Senate, AB 249 makes it very clear, this is quoting him, makes it very clear to a voter when they receive a mailer that is coming from an independent expenditure and not a campaign. That was the whole point of the legislation, was to make clear, prominent, and consistent disclosures on ballot measure and independent expenditure committees, because people will tend to assume that a mailer about a candidate comes from the candidate themselves if they don't understand that it's coming from an independent expenditure group. That's why a threshold under 200 is okay on candidate paid committees, but not okay on independent expenditure committees. So this was very, very intentful. We have a couple, I know there were at least a couple other public comments that are going to talk about. We understand that the reasoning behind the regulation in 2002 was laudable by trying to avoid having individuals have to have these disclosure requirements if they're printing off a couple of yard signs or a couple of flyers or things like that. AB 249 addresses that by saying that its disclosure requirements only happen for committees. So that original reason for the regulation number of 200 doesn't apply to AB 249 because only committees have to have that. If you're looking at burdens on committees who have to have a certain amount of sophistication because they have to become committees and file all that paperwork, we believe, and we believe other public comment will testify, there would actually be an increased burden on committees to have two separate kinds of disclosure on them for ballot measure and IE committees. The disclosures are required if they have over 200 items printed, or the disclosures required, i.e. none, if they're under 200. And the additional record keeping and receipts, how are they going to prove that they printed less than 200? What if they printed it on their printer in their committee office, as many small committees will do? I think there's lots of concerns about that. Furthermore, we are also concerned about the public. The whole point of AB 249 was so that the public could expect to see clear and prominent and consistent disclosures on ballot measure and independent expenditure ads. If they sometimes get, and recognize that, and if they sometimes get ones without any disclosure, how are they supposed to know whether it's a committee that is in violation because they printed over 200 and didn't include the disclosure, or one that is under 200? So I suspect you'll see members, if you keep this threshold with these new, clear, prominent disclosures, you will see members of the public who will falsely or not falsely make complaints about violations of the disclosures not appearing simply because they got ones that were under 200, but they didn't know that. So for all these reasons, and explicitly, we've consulted with our counsel, who is an acknowledged expert on administrative and regulatory law, and as he describes, there is no statutory basis for the 200 level applying to committees that are not defined in 84305 or 84310. We think it would actually be an increased burden on committees, not serve the public, and certainly not serve the intent of AB 249. And I can answer your questions, or we have other
public comment or a question for him.
Yeah.
Commissioner Hatch?
Not so much a question, but in the future, I think it would serve you well, and it would help us if, when you write a letter like this, you include a draft of your own markup of what those regs should look like.
Okay, good point. Thank you.
It helps resolve a lot of otherwise confusing conversations.
Right. Good point. And we do describe in the other letter these two different ways that you could address it, either, as you were discussing, by putting in the committee caveats one way or the other. And I also discussed with staff another option, which is to say that those sections 3, 4, 5, and 6 of the regulation actually don't add anything, because those are defined as advertisements already in section 84501. So a possible alternative is to actually just strike those paragraphs because they are laid out in the statute 84501, and then 84305 and 84301 have the different quantity thresholds for the appropriate committees.
And there is an opportunity for you to still do that.
Yes.
Appreciate it if you...
Yes, we shall do so.
Okay. Any additional public comment?
Good morning, Chairman Remke and Commissioners. My name is Shane McLeod, and I'm speaking on behalf of MOVI, Money Out Voters In. My experience is working with this organization, with Trent's group, California Clean Money Campaign, and as a former campaign manager to last year's statewide initiative campaign, Voters' Right to Know. I urge you to implement draft regulation 18450-1A, which would not implement it, which would exempt certain communications under 200 pieces with the California Disclosure Act's requirements. As has been noted, this will complicate matters for some committees, like the committee MOVI operated in 2016 in support of Proposition 59, a truly grassroots campaign with enough decentralization and volunteer participation such that it would not only have been nearly impossible to find a way to track who was printing what and how many, but try as we might, we'd likely have been unsuccessful. More troubling to us is what a well-funded campaign with donors who would like to remain anonymous might do with that 200-piece limitation. What sort of whisper campaign could come outside of the disclosure requirements? We can start with what would constitute a different communication. Is one word or is it 20? Imagining the ways in which this is seemingly tiny, and I'm sure well-intentioned exemption might play out during an actual campaign alarms us and does not, we think, reflect the intentions of the California legislature when they passed the Disclose Act, nor the wishes of the California voters who worked so hard to achieve major donor disclosure on political advertising. Our concerns are with how big committees would use the 200 flyer loophole by just creating enough different communications, each sent out in 200 or less. It'd be especially problematic for local races. You may have thousands. These committees may have thousands of volunteers who work to pass, or I should say, thousands of volunteers who work to disclose the Disclose Act. Wanted it to be clear AB 249 disclosures on all ballot measures and independent expenditures ads, not to have exceptions for some communications due to how many they were sent in. The additional burdens on small committees like MOVI and Voters' Right to Know and any of these smaller groups, grassroots organizations, keeping all the records of how many copies of each communications were sent out to prove whether you sent out 200 or fewer. It would just be too burdensome. Thank you for your consideration.
Thank you. Any additional public comment?
Good morning, Chair and Commissioners. My name is Jack Blattner with California Common Cause. As strong supporters of AB 249 as it passed through the legislature, I wanted to start by thanking the Commission for how quickly it has moved to conform and update its regulations to the bill. We see no problems with most of the newly proposed regulation changes that staff has brought forward, but like California Clean Money Campaign, Money Out, Voters In, and the Author's Office, we would urge the Commission to reject the proposal to exempt some communications produced in quantities of less than 200 from AB 249's disclosure requirements. Exempting certain communications produced by campaign committees runs contrary to AB 249's text and intent. One of the primary purposes of AB 249 was to create uniform, predictable disclosures that voters could easily identify on advertisements. Exempting certain communications from AB 249's requirement creates two reporting rules and potential for unnecessary confusion, both to filers and to the public. We also fear that enforcement of the 200 copies or fewer provision would be difficult, if not impossible. For bad actors, the 200 copies or fewer requirement would be easy to circumvent, as committees could print in-house with little possibility of auditing or use several different vendors to make counting print runs difficult. For good actors, the provision might force campaign committees to keep proof that their advertisements were produced in small batches, which could prove burdensome. Good actors could also retroactively violate the bill or the regulation by printing a run of 150 so copies and then later printing more, thereby making the first print run retroactively violate the regulation. Finally, the proposed threshold would also reduce disclosure of who is funding ads, the primary purpose of AB 249. For example, under the draft proposal, 199 yard signs could be printed without disclosing funders, which over the course of a campaign would likely be viewed by thousands of voters. For these reasons, we echo the California Clean Money Campaign and the Author's Office in respectfully requesting that the Commission amend the draft regulation to apply to all campaign advertisements, regardless of quantity. Thank you.
Thank you. Is there any additional public comment?
Good morning, Madam Chair and Commissioners. My name is Laura Fitzgerald. I'm here on behalf of Assemblymember Kevin Mullen as a member of his legislative staff. Just here to share some of his comments. On behalf of Assemblymember Mullen, the author of the California Disclose Act, I'd like to thank the Commission and its staff for working so diligently on the regulation changes needed to implement it. One important issue that he has, however, is on draft regulation 18450.1A's requirements that certain communications be in quantities of 200 or more to be considered an advertisement in paragraphs 3, 4, 5, 6, and 8. He would like to make clear here that this was not the intent of the legislature and definitely not his intent as author of AB 249. AB 249's section 84501A's definition of advertisement very clearly spells out the intended exceptions to when communications are to be considered advertisements. There is intentionally no reference to the number of communications required to be considered advertisements, nor is there any reference to the number of communications required for their disclaimers requirements in sections 84504 through 84504.4. Instead, AB 249 specifically only includes quantity requirements in sections 84305 and 84310 regarding advertisements paid for by a candidate-controlled committee established for an elective office for the controlling candidate, or political party committee. The reason for this difference, as described by the California Clean Money Campaign's letter of December 11th, is that voters will automatically tend to assume that ads without disclosures are paid for by candidates, so it's okay if ads paid for by candidates in small numbers don't include disclosures. But it is not okay for ads regarding ballot measures or independent expenditures for and against candidates not to include disclosures regardless of quantity. We also agree with the other signers of the letter describing how having different disclosure requirements for committees based on the quantities of ads printed would be a burden on ballot measure and independent expenditure committees that not only goes against the intent of AB 249, but is counterproductive to the information needs of the voters. Thank you for your time this morning. I appreciate you giving me the opportunity to share some of Assemblymember Mullen's comments, and we ask that you consider some of the solutions and comments brought forward by the California Clean Money Campaign. Thank you.
Thank you. Any additional public question? Commissioner Hatch?
Question of the speaker.
She has a question for you.
Of course.
Since you're the representative of the author, I just ask you to consider whether the actual candidate campaign should even need to put a disclaimer on, considering the assumption that unmarked material is from the campaign.
If it's all right, I don't believe that I'm the person to answer questions. I think that I'd like to defer to Trent with the Clean Money Campaign, if that's all right. Thank you.
To answer your question, obviously we as sponsor, and we believe Assemblymember Mullen also do believe that candidate committees generally do need to provide disclosures, especially when they're doing large numbers of print materials and so forth. But under small numbers, under the history of the Commission's regulations on that, as sponsor, we thought it was acceptable to have under 200 paid for by candidates not have the disclosure. I'm not asking
Excuse
you what
me,
is.
Commissioner Hatch, can you please bring the microphone closer so those on the phone can hear?
Sure, thanks. I wasn't asking you what is, but rather why should we? Since the public generally thinks that a piece of campaign material that doesn't have any disclosures is probably from the campaign, why do we even require the campaigns to put a disclosure on? It seems like a sort of an oxymoron.
Well, we would think that it's useful to that candidate committees and political party committees in AB 249 don't have to show their top donors and so forth, but we believe that it's helpful to the public to be able to easily identify the committee that paid for the ad when there are truly mass mailings and that are going to affect large numbers of people. So it's partially identifying the committee that's responsible.
Okay. Thank you.
Any additional public comment on this item? Okay. Is there a motion? I would propose that we put it over to January and come back with an option 3, which is outlined in the letter, so then we can see the 3 options in front of us and have a more
Chair Remke,
clear.
just a point of order.
Probably February, right?
I'm thinking that this would need to go out for an interested persons meeting again.
Yeah, because this is a whole new idea. But the idea would be to bring it back with the 3 options completely drafted out, so we could see what is being said and make sure we all understand it. Because I still think there's an issue. So let's do that. Take it back to an interested person meeting. And is that agreeable?
Yeah, I would agree with that. I think, you know, we've got a question about thresholds here that I think is not just about AB 249 or what might be in the statute and what might be in the reg, but other restraints on constraints on our authority in case law. And so if we could have a more fulsome, you know,
Right.
discussion of those kinds of issues, hopefully the regulated community will help us along the way.
And and I know that you tried to stay within the existing regulation with the one option too, but the way I'm hearing option 3, it might have to be a whole redraft of a reg to make it more understandable, because I could tell you from my point of view right now, this option 3 is as confusing as AB 249. So I'd hope we can help out and make it a little clearer if we're going to go a third route. So you'll draft it up, work with the interested persons, and then bring it back to us, and we'll have a further discussion on this.
Thank you.
Thank you. Okay, item 37.
Good morning, Chair Rimke and Commissioners. I'm Zachary Norton, Senior Counsel with the Legal Division. And today, staff is proposing, at the direction of the Commission, amendments to Regulation 18535. Regulation 18535 was originally adopted to provide clarification regarding the limits on intercandidate transfers. At its July meeting, the Commission discussed the intercandidate transfer limit, which at that time applied to state candidates who were the subject of a recall election. The Commission subsequently adopted an opinion, as well as amendments to Regulation 18535, permitting unlimited contributions from a state candidate to another state candidate who is the subject of a recall. During deliberation on those regulatory amendments, a comment letter was received asking the Commission to consider reversing its longstanding interpretation that limited one state candidate's contributions to another state candidate's legal defense fund and candidate-controlled ballot measure committee. Although the Commission could not take action on this proposal at that time, it did direct staff to prepare an amendment incorporating these changes. Staff has prepared an amendment to Regulation 18535 as requested, which would expressly permit unlimited contributions from a state candidate to another state candidate's legal defense fund and candidate-controlled ballot measure committee. And with that, I open it up to questions.
Any questions from the commissioners?
No, I think it's clear.
No, in general, I'm pleased with the draft.
Okay, any public comment on 18535?
Madam Chair, Commissioners, Richard Rios here, just in support of the staff's draft of the proposed regulatory changes. Happy to answer any questions.
Is there a motion?
I'll move approval.
A second.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
No.
Motion
So,
does not pass.
so there's no action, and we'll bring it back for January, if that is the will of the commissioners.
Yes, please.
Okay, so it'll come back in January. So the next item is thank you, Zach, is the executive staff reports. Any questions from the commissioners for staff on the reports? I think there is one update for, that, in fact, just on Burgess, on the legal division, that they did file their brief. Is correct? Correct. Okay, just, that was the update. That's page 4 of the staff.
Yeah, we saw the answer.
Yeah, so that's, Any other questions or comments from commissioners on the report? Commissioner Hayward?
No.
No.
Okay, thank you. It will be submitted. And then the last item is just hearing from the commissioners about any items that have not already been talked about that will be on future agendas. I do have a running list for January already, not in front of me, but is there anything new that we haven't discussed or brought up that they'd like to have placed on the agenda?
I would like to consider. Oh, that's nice music. Thank you. Yeah, we should have little musical interludes in between people. I think that would really be nice.
I'll put that on a future agenda.
Interludes. A server that works, all kinds of things. Okay. Under January 2018, in the staff report, I noticed that we may have a pre-notice discussion of possible amendments to the conflict of interest rules as applied to small shareholders and related business entities. I don't know what preferences others might have, but I would like at some point to there be in the possible amendments to conflict of interest rules a slight modernization of how we approach family trusts. And I don't know if that's something that needs to be done in January or something we just think about, but you know, as it stands right now, a lot of people who, for estate planning purposes, have family trusts that are, you know, totally revocable inter vivos and are taxed just like your, you know, bank account outside of a trust would be. The way the reporting is handled right now, they're reported as separate entities, and I think that's actually a bit confusing because it looks like you might have like a business that's got this family trust name to it. And it's not that at all. It's just your personal property that's being held in a different legal format for estate planning purposes, not for any other purpose. You know, I'm of course like, terribly aggrieved by this because it's my situation. But I think it's a situation a lot of people find themselves in. If this is something that we have the power to do something about, I'd like to look into that.
So I would recommend that Commissioner Hayward work with Brian, who just came to the table.
Yes.
And
Hi, Brian.
then I won't put it as far as a month, but a future possible agenda, depending on what you guys come up with and what you propose. It's similar to what's on the pre-notice on the other conflicts that I know Commissioner Hatch is working with Brian as well. And that timing will also just be based on when they come together with something they think is ready for the agenda. But we will add yours as well, probably just without a month until you guys get somewhere. Okay,
Awesome.
Brian? Thank you.
That's good.
All right, anything else? If not, I'll move to adjourn.
Second.
Commissioner Hatch? Commissioner Hayward?
Yes.
Chair Rumkey?
Yes.
Motion passes.
All right, thank you, everyone.